Hello and welcome to the Minimum Competence episode for Thursday, July 3rd, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have Roberts reasserting control at the Supreme Court, RFK Jr.'s HHS overhaul blocked, Trump's asylum ban struck down, and a battle over CPSC firings heads to the court. Let's remember, conformity is the jailer of freedom and the enemy of growth. And read today's legal news. On this day in legal history, July 3rd, 1978, the United States Supreme Court issued a landmark First Amendment decision in FCC v. Pacifica Foundation, ruling 5-4 that the Federal Communications Commission, that's the FCC for those in the know, could reprimand a radio station for airing George Carlin's infamous 7 Dirty Words comedy routine. The case arose after WBAI, a New York radio station, broadcast Carlin's monologue during afternoon hours, prompting a listener complaint to the FCC. The FCC responded with a formal reprimand, sparking a legal battle over the boundaries of free speech and government regulation. The court held that the FCC had the authority to regulate indecent content on public airwaves, particularly during hours when children were likely to be listening. Justice John Paul Stevens, writing for the majority, emphasized the unique pervasiveness of broadcast media and its accessibility to minors as justification for the ruling. The decision marked one of the first times the Supreme Court allowed government regulation of speech based on content outside of traditional obscenity laws. Dissenting justices, including William Brennan and Thurgood Marshall, warned that the decision posed a threat to free expression and could chill controversial or creative speech. The ruling did not criminalize Carlin's routine or ban such speech outright, but it set a precedent that the government could impose content-based restrictions on broadcasters without violating the First Amendment. This case would come to define the limits of indecent speech in broadcast media for decades, reinforcing the idea that First Amendment protections are not absolute in all contexts. The decision became a cornerstone in the ongoing tension between free speech rights and government regulation of media. Chief Justice John Roberts appeared to regain influence over the Supreme Court this term, joining the majority in 96% of argued cases, dissenting in only 2 of 58 decisions. Legal scholars, however, caution that this high rate doesn't definitively prove Roberts' steering outcomes. Some suggest that his tendency to vote with the majority might reflect a strategic desire to maintain influence or unity rather than genuine agreement. Roberts, along with Justices Kavanaugh and Barrett, now forms a pivotal center block on the ideologically divided court, often determining case outcomes between the court's conservative and liberal wings. These 3 justices were all in the majority for the 10 most contentious 6-3 rulings this term, shaping major decisions on issues like LGBTQ curriculum, gender-affirming care, and administrative power. Observers note that Roberts' leadership this term was marked by a careful assignment of majority opinions, often to maintain consensus among conservatives. For example, he gave the opinion in Trump v. Casa to Barrett, whose more moderate reasoning helped avoid a fractured ruling. Notably, Roberts wrote no separate concurrences or dissents, reinforcing the view that he is trying to project cohesion. However, consensus was not the norm this term. The court split significantly in 1/3 of its cases, and unanimous rulings fell to 43%. Many of the most ideologically charged outcomes favored conservatives, suggesting that even with Roberts at the center, the court remains deeply right-leaning. Additionally, significant decisions from the court's emergency docket further indicate the direction of future jurisprudence. A federal judge has blocked parts of a major restructuring of the U.S. Department of Health and Human Services initiated by Secretary Robert F. Kennedy Jr., but the ruling does not require the reinstatement of fired workers. The decision in New York v. Kennedy found that 19 states and Washington, D.C. are likely to succeed in their claims that Kennedy's reduction in force and reorganization, part of his Make America Healthy Again plan, were unlawful. The injunction halts further implementation but stops short of restoring the affected employees, leaving unresolved the harms states allege, including disrupted services and surveillance functions. Legal experts point out the ambiguity in the ruling, noting it restricts further actions by HHS but does not mandate concrete remedies, such as bringing employees back. Some warn that continuing to keep workers off the job could itself violate the injunction. The injunction is limited to 4 HHS divisions, not the full federal workforce affected. The ruling requires HHS to file a compliance update by July 11th and address how the recent Supreme Court decision in Trump v. Casa, which limits the scope of national injunctions, may influence the outcome. HHS has multiple potential responses: appealing the ruling, waiting for developments in a related Supreme Court case, or restarting the process through proper legislative and budgetary channels. A federal judge has blocked President Donald Trump's sweeping asylum ban at the U.S.-Mexico border, ruling that Trump exceeded his legal authority. U.S. District Judge Randolph Moss found that Trump's January 2025 proclamation, which barred migrants deemed part of an invasion from seeking asylum, violated both federal immigration law and the Constitution. The 128-page opinion emphasized that neither Congress nor the Constitution gave the president power to bypass existing asylum laws, even in the face of immigration challenges. The American Civil Liberties Union, or ACLU, filed the lawsuit on behalf of advocacy groups and asylum seekers, arguing the ban contradicted U.S. and international legal standards. Moss's ruling temporarily blocks enforcement of the policy and allows 14 days for the Trump administration to appeal. The decision applies broadly to a certified class of affected migrants, sidestepping recent Supreme Court limitations on national injunctions. Trump's policy built on but exceeded a similar effort by President Biden in 2024, which also faced judicial setbacks. The ruling marks another legal rebuke to Trump's aggressive immigration stance since returning to office. The administration maintains the judge overstepped and vows to appeal. Meanwhile, civil liberties groups hailed the decision as a necessary check on executive overreach and a reaffirmation of asylum protections. President Donald Trump has asked the U.S. Supreme Court to intervene in his effort to remove 3 Democratic members of the Consumer Product Safety Commission, or CPSC, challenging a lower court's ruling that blocked their dismissal. The commissioners, Mary Boyle, Alexander Hohn-Sarek, and Richard Trumka Jr., were appointed by President Biden and make up the majority of the 5-member board. They were fired in May, prompting a lawsuit that argued the president lacks authority to remove commissioners of independent agencies without cause. A federal judge, Matthew Maddox, sided with the commissioners, stating Trump had overstepped his authority and finding no misconduct to justify their termination. The Justice Department claims Trump acted within his constitutional powers, asserting that the commissioners were obstructing his policy agenda. The administration is seeking to pause the reinstatement order while the case proceeds. The Fourth Circuit Court of Appeals declined to halt the lower court ruling, emphasizing that Congress lawfully limited presidential removal of powers in this context. Trump's team now wants the Supreme Court to override that decision, citing a recent high court ruling that allowed Trump to temporarily remove members of a federal labor board in a similar dispute. This case adds to a growing list of legal battles testing the limits of executive power since Trump returned to office. It also raises broader constitutional questions about the balance of power between the president and independent regulatory agencies. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, forgive your enemies, but never forget their names.